Hello everyone, good evening. Can you hear me? Am I audible? Okay. Okay, so due to some technical issues I have been facing, and there were some technical issues at the other end also. So there's a delay of 10 minutes, and I'm really sorry for this, because these things are beyond somebody's control. So I'm trying to fix the situation, fix the problem since morning. So okay, so let's start the class without wasting any more time. We have today's topic is the Tribunal Reforms, Rationalization and Conditions of Service Ordinance 2021. So what are tribunals? Okay, what are tribunals? Tribunals are special courts that have come into existence over the period of many years, many years, and these tribunals have been set up in order to shrug off the loads, the heavy loads on the shoulders of the judiciary. Since the judiciary has been facing a huge backlog of cases, the normal conventional courts called the district courts, the high courts and the supreme courts have been facing huge backlog of cases, and these institutions of judiciary have been seem to be overloaded unreasonably with all kinds of cases. Like, they have cases on the finance, they have cases on the environmental issues, they have commercial disputes before them, they have constitutional cases before them, they have criminal cases before them, they have civil and property cases before them. Like, every breed of case is lying sub judice on the tables of the Indian judiciary, and the Indian judiciary seem to have, there is a huge backlog of cases, these kinds of cases in the Indian judiciary. So tribunals have been set up over the years, so that a different type of tribunals have been set up, so that different issues can be sorted out by different special courts. For example, we have company law tribunal. So if I'm citing this, I'm giving you just as an example. Like, company law tribunal is working as a special court to dispense cases and disputes relating to the company law. Similarly, we have the National Green Tribunal today to dispense cases with regard to the cases of environmental law. Okay, we have special tribunals for each and everything. You can give the examples right now to me. There we have a lot of tribunals now, so that there is a speedy disposal of cases, because the tribunals are meant to dispose of the cases speedily, because National Green Tribunal does not seem to be overloaded with the huge number of cases, because its only job is to dispense cases of environmental nature. So what is National Green Tribunal doing? NGT is simply dispensing cases of environmental nature. That's it. Okay, so it is hardly receiving huge number of cases, and it is whatever cases it is receiving, it is dispensing it well in time. Same is the case with other kinds of tribunals also. Okay, now the Tribunals Reforms, Rationalization and Conditions of Service Ordinance 2021, I checked it in the morning, it has already become an act. So let us understand the features of the bill, highlights of the bill, why this Tribunals Reforms Ordinance 2021 has been brought. Highlights of the bill. The bill dissolves certain existing appellate bodies and transfers their functions to other existing judicial bodies. Okay. Now the bill dissolves certain existing appellate bodies. We have a number of appellate bodies. What are appellate bodies? Bodies who entertain, who exercise appellate jurisdiction. What is an appellate jurisdiction? The power to receive appeals against the orders of the lower court. Okay. motor accident claim tribunals. Yes, yes, yes. But motor accident claims tribunals is a special court within the district court. Okay, I'm talking about kind of tribunals that we have like the NGT, okay, or the company law tribunal, or the CAT, Central Administrative Tribunals. Okay, these kinds of tribunals, like huge army tribunals. Okay, different institutions altogether. So what are appellate bodies? Appellate bodies are the bodies who exercise who possess the appellate jurisdiction. The appellate jurisdiction is simple. Okay, appellate jurisdiction is the power to receive appeals and entertain appeals and try the appeals against the orders of the lower courts. Okay, so we have like company law tribunal, then we have the company law appellate tribunal. Okay, so we have certain appellate bodies. So what does this bill do? Intends to do? The bill dissolves certain existing appellate bodies and transfers their functions to other existing judicial bodies. Okay, to other existing judicial bodies. The term of office for the chairperson and members of our tribunals will be 4 years, subject to an upper age limit of 70 years for the chairperson and 67 years for other members. See, that's how it's going to work. Okay, the term of office for the chairperson and members of tribunals will be 4 years. Okay, there is going to be a chairperson who usually heads, who usually becomes the chairperson of a tribunal. Obviously, a retired Chief Justice of India or a retired judge of the Supreme Court. Okay, so who is what's going to be the term of office for the chairperson and members of a tribunals? It's going to be 4 years, subject to an upper age limit of 70 years. Subject to an upper age limit of 70 years for the chairperson and 67 years for other members. Okay, subject to an upper age limit of 70 years for the chairperson. What is going to be the retiring age? It's 70 years. 67 years is for the other members. Like, these are very simple nuggets of information. You can just may have a bare perusal of this PDF doc and you will understand the whole issue. Okay, the bill specifies that a person should be at least 50 years of age to be eligible for appointment as a chairperson or member. Anybody who is or who has to be appointed or who needs to be appointed as a chairperson, he has to be at least 50 years of age or 50 years older to be eligible for appointment as a chairperson or member. Okay, like that is the minimum. Now, what are the key developments? Because these are just normal highlights of the bill. Okay, the key developments are, because what has been happening since last so many years with regard to these bringing this tribunals reforms. Okay, yes, NCLT, Ankita. NCLT, I have already given an example of NCLT. National Company Law Tribunal is one of the best examples we can have. In March 2017, the Finance Act 2017 reorganized the tribunal system by merging tribunals based on functional similarity. The total number of tribunals was reduced from 26 to 19. It delegated powers to the central government to make rules to provide for the qualifications, appointments, terms of office, salaries and allowances, removal and other conditions of service for chairpersons and members of these tribunals. Okay, we have the Finance Act of 2017. Now, based on the functional similarity, since so many tribunals have similar functions, and yet they were separate tribunals. They had similar functions, yet they were separate tribunals. So the Finance Act 2017, in March 2017, the Finance Act 2017 reorganized or fine-tuned the tribunal system by merging tribunals based on functional similarity. Okay, the total number of tribunals was reduced from 26 to 19. It delegated powers to the central government to make rules to provide for the qualifications, appointments, term of office, salaries and allowances, removal and other conditions of service for chairpersons and members of these tribunals. Okay, qualifications, appointments, term of office, salaries and allowances, removal and other conditions of service for chairpersons and members of these tribunals. Okay. Now, the Finance Act of 2017 already delegated some powers to the central government to make rules to provide for the qualifications. Like, the central government already had the power to make rules with regard to these kinds of things. Okay, what are going to be the qualifications of the members of the tribunals? How are they going to be appointed? What is going to be the term of office? What is the salary structure and allowances? What is the removal procedure and other conditions of service for chairpersons and members of these tribunals? Okay. Now, they were merged based on their functional similarity. Now, in June 2017, this is important. I hope this PDF is visible to you. In June 2017, the Ministry of Finance notified rules which specified details including qualifications of the tribunal members, their terms and conditions of service, and composition of the search cum selection committees. In June 2017, what happened? The Ministry of Finance notified rules which specified details including qualifications of the tribunal members, their terms and conditions of service, and composition of the search cum selection committees. So what happened in June 2017? This was about March 2017. Now in June 2017, Ministry of Finance notified rules which specified details including qualifications of the tribunal members, their terms and conditions of service, and composition of the search cum selection committees. In November 2019, the Supreme Court struck down the 2017 rules. Do you remember right now the rules that were framed in March 2017? They were struck down by the Supreme Court in November 2019. The court stated that the rules did not meet the requirements laid down in earlier judgments mandating judicial independence in terms of 1. Composition of the tribunals, 2. The security of tenure of the tribunal members, and 3. Composition of the search cum selection committees. So the court stated that the rules did not meet the requirements laid down in earlier judgments mandating judicial independence. Okay. The court stated that the rules did not meet the requirements laid down in earlier judgments mandating judicial independence in terms of 1. Composition of the tribunals, 2. The security of tenure of the tribunal members, and 3. Composition the search cum selection committees. Like, we have these kinds of things. Okay. Now the court directed the central government to reformulate the rules. The court directed the Abhinav, I have already shared the PDF on the group. Okay. Now what Ankita is asking? All India tribunals? I mean, what do you mean? What is the full question? What is the question? Okay, so the court directed the central government to reformulate the rules. Key concerns that the court wanted addressed include: 1. Short tenures which prevent enhancement of adjudicatory experience and thus impact the efficacy of tribunals. And 2. Lack of judicial dominance in selection committees, which is in direct contravention of the doctrine of separation of powers. Do we have the doctrine of separation of powers? Under which article do we have this doctrine of separation of powers? Okay. Do you remember learning a doctrine of separation of powers? Yes, Ankita, this ordinance relates to the All India tribunals. Yes, Ankita, that's right. All India tribunals. Article 50, that's the right answer. We have separation of powers in Schedule 7, you are right. But right now we are talking about separating executive from judiciary. So we have like different institutions together. Okay. Okay. So the court directed the central government to reformulate the rules. Key concerns that the court wanted addressed include short tenures which prevent enhancement of adjudicatory experience and thus impact the efficacy of tribunals. 2. Lack of judicial dominance in selection committees, which is in direct contravention of the doctrine of separation of powers. Like, the court wanted that if you have the powers to decide about the qualifications of the chairperson and the members of the tribunals, and if you also possess the powers to decide about the everything regarding their services, like the retiring age, the tenure or the term of the office, the qualifications and everything, then it's going to like you have to be like, it's very you cannot put short tenures, okay, because they are going to prevent the enhancement of adjudicatory experience. How can we expect a person who does not have a good experience to become the chairperson or member of a tribunal? Similarly, how can we expect the judiciary to dominate in the appointment process exactly the same way it does in the appointments of the judges of the higher judiciary? Okay. So which is in direct contravention of the doctrine of separation of powers. In February 2020, the new rules were notified, which were again challenged in the Supreme Court mainly over the lack of conformity with the principles laid out earlier by the court. For example, the 2020 rules specified 4-year term of office against 5 years as specified by the Supreme Court in 2019. Okay, in February 2020, new rules were notified, which were again challenged in the Supreme Court over the lack of conformity with the principles laid out earlier by the court. For example, the 2020 rules specified 4-year term of office against 5 years as specified by the Supreme Court in 2019. Like I said, the Supreme Court's concern was that do not appoint a person as a chairperson who has less number of years as his experience. You should appoint a person who has like major experience, and also short tenure nahi hona chahiye. This shouldn't be 4 years, this should be 5 years. But again, when again in 2020 the another set of rules was framed by the central government, it again specified the same 4-year term in place of 5 years as specified by the Supreme Court in 2019. Okay, so this was the concern, and again they were challenged. The court suggested certain amendments to the 2020 rules, such as increasing the term of office to 5 years along with eligibility for reappointment. Okay, subject to upper age limits. Obviously, if a person is reaching the retiring age, then obviously he cannot be reappointed. But if he possesses that like some period to come of a retirement age, and before reaching that the age of superannuation, he can be reappointed, and allowing advocates with 10 years experience to be appointed as judicial members. Like if you have 10 years of experience, you can be appointed as judicial members. This should be allowed, the court said. The Tribunals Reforms Rationalisation and Conditions of Service Bill 2021 was introduced in Lok Sabha in February. As the bill was pending at the end of the session, an ordinance with similar provisions was promulgated in April. Alright. Under the Finance Act 2017, now listen to me very carefully. New rules were notified on June 30, 2021. The rules allow advocates with 10 years relevant experience eligible for appointment as judicial members and provide details on house rent allowance for members. Okay. The Finance Act 2017, under the Finance Act 2017, new rules were notified on June 30, 2021. The rules allow advocates with 10 years relevant experience eligible for appointment as judicial members and provide details on house rent allowance for members. Okay. The ordinance and the rules were challenged in the Supreme Court. The court struck down provisions related to the 4-year tenure and the minimum age requirement of 50 years for members of tribunals. Okay. Now, key issues and analysis. This is the main part. the term of office of 4 years is lower than the minimum of 5 years directed by the Supreme Court in various judgments. First thing, that this office, this term of office of 4 years is obviously lower, as I have already discussed. Okay, that this term of office of 4 years is lower than the minimum of 5 years directed by the Supreme Court in various judgments, right? The Supreme Court has also noted that the minimum age limit requirement of 50 years for appointment of members may discourage young talent. It had earlier directed that advocates with 10 years of experience be made eligible to be appointed as a judicial member. Okay. The Supreme Court has also noted that the minimum age limit requirement of 50 years for appointment of members may discourage young talent. Okay. क्या कहा Supreme Court ने? I am reading it again. Has also noted that the minimum age limit requirement of 50 years for appointment of members may discourage young talent. Why are you raising the bar of age? If some young talent wants to become a judicial member, why shouldn't he be encouraged by means of reducing the age bar? It had earlier directed that advocates with 10 years of experience be made eligible to be appointed as a judicial member. Like, advocates with 10 years of experience are quite young. Okay. And probably, obviously, he's not going to be 50 years of age, unless he must have started his practice at the age of 40 years, and then he might have gained the 10 years experience at the age of 50. That is a different and a special circumstance and something different. Okay. But that's not going to be the case with everyone. Like, usually people start, like most of the young talents, they usually start practicing. The one who are passionate about litigation, they start practicing in the late 20s. So if they are going to be like have 10 years of experience, they might be like less than 40, around 38 years of age or 39 years of age. That's still young. So the Supreme Court is wanting these young talent to come and become the judicial members of the tribunals, different members of the tribunals. So it had earlier directed that advocates with 10 years of experience be made eligible to be appointed as a judicial member. Okay. Now, abolishing tribunals may increase the disposal time for new cases, as high courts already have a large number of cases awaiting judgments. Why did we establish the tribunals? Why did we start establishing tribunals? Like the way when we discussed that case, do you remember that case, Pandurang Ganpati case we discussed regarding the some bank issue we discussed? Do you remember? What did I tell you regarding the debt recovery? How, debt recovery tribunal was established in 1993 because a need was felt for the banks to go directly to the debt recovery tribunals instead of the normal conventional high courts, because high courts are already overburdened with lots and lots of cases. So in order to get the issues resolved speedily, a need was felt in 1992 to have separate debt recovery tribunals so that the banks cannot wait for the recovery of their debts. Okay, because this is an issue which has to be resolved immediately. So this is just an example that I am citing here. Similarly, since the normal conventional courts are already overburdened with lots and lots of cases, so we have like special courts dealing with different cases of different nature. Like today we have National Green Tribunal, we have Company Law Tribunal, okay, we have like Central Administrative Tribunal. Okay, yes Ankita, banks and surface side, Central Administrative Tribunals. Okay, so these tribunals, these special courts were established so that all the high courts, especially the high courts are like the burden can be shrugged off from the shoulders of the high courts, and these different cases of different nature should be allotted to different tribunals, and these tribunals would then dispose them of quite speedily. So these were the objectives behind establishing tribunals. Now this ordinance has been brought in 2021, this bill has been brought in 2021 to abolish some tribunals. I mean, this is really going to create difficulty in the future, because it's going to take us to the same situation, like back to square one, from where we had already started. We have been facing huge backlog of cases in the normal conventional courts, and the same we are going to face it again, because this ordinance pertains to abolished tribunals. So abolishing tribunals may increase the disposal time for new cases, as high courts already have a large number of cases awaiting judgments. So this is a serious issue. Okay, so the analysis is that the ordinance has not come like a good news for the Indian judiciary. Okay, now timeline on recent developments related to tribunal reforms. Highlights of the bill. The context. The Tribunal Reforms Rationalisation and Conditions of Service Bill 2021. What is the name of the case whose guidelines are being discussed in the PDF? This is not a case. We are not discussing any case. This week we are discussing certain topics, current legal topics. The next week we are going to discuss cases. Okay, we have alternate sets of things to be discussed in alternate weeks. The first week we discussed some current legal topics. The next week we discussed the judgment summaries. This week we are again discussing legal current topics. Next week we are going to come back on the judgment summaries. That's how it goes. This is not a case. Okay. Highlights of the bill. Context. The Tribunal Reforms Rationalisation and Conditions of Service Bill 2021 was introduced in Lok Sabha on February 13, 2021. It proposes to dissolve certain existing appellate bodies and transfer their functions to other existing judicial bodies. It proposes to dissolve certain existing appellate bodies and transfer their functions to other existing judicial bodies. Further, it proposes to include provisions related to the composition of selection committees and term of office in the Act itself. Okay. कब इंट्रोड्यूस हुआ था लोकसभा में? February 13, 2021 को हुआ था. It proposes to dissolve certain existing appellate bodies and transfer their functions to other existing judicial bodies. बाकी judicial bodies के यहाँ ट्रांसफर हो जाएंगे और ये सब डिसॉल्व हो जाएंगी. ट्राइब्यूनल्स जो भी ट्राइब्यूनल्स इसमें सबकी सब नहीं होंगी, लेकिन कुछ हो जाएंगी इसमें से. Certain existing appellate bodies. Further, it proposes to include provisions related to the composition of selection committees and term of office in the Act itself. Okay, like there's going to be a selection committee which is going to appoint, that selection committee is going to appoint the members of the tribunals. So that composition of the selection committees has to be decided by the Tribunal Reforms Ordinance Bill 2021. Okay, and term of office in the Act itself. An ordinance with similar provisions was promulgated in April 2021. The ordinance was challenged in the Supreme Court over its lack of compliance with past Supreme Court judgments on tribunals. In July 2021, the court struck down certain provisions of the ordinance. Now, key features: abolishing of appellate bodies and transfer of functions. The bill abolishes certain appellate bodies and transfer their functions to existing judicial bodies. You can see the table. We have the table. Transfer of functions of key appellate bodies. I'm reading it again. The bill abolishes certain appellate bodies and transfer their functions to existing judicial bodies. Okay? Transfer their functions to existing judicial bodies. There is one question. What is the difference of existing appellate bodies and existing judicial bodies? What is the difference of existing appellate bodies and existing judicial bodies? For example, there is a company law tribunal, National Company Law Tribunal. What is it? What it is known as NCLT. Okay. Then there is Company Law Appellate Tribunal. If there is any company law dispute, the dispute will go to National Company Law Tribunal. If you are not satisfied, you being a party to the dispute are not satisfied by the judgment of the NCLT, you can make an appeal. Where will you make an appeal? Company Law Appellate Tribunal, NCLAT, National Company Law Appellate Tribunal. Okay, National Company Law Appellate Tribunal. Okay, then National Company Law Appellate Tribunal. These are the appellate bodies which have been, attacked by this Tribunal Reforms Ordinance. We have lot of appellate bodies, certain appellate bodies. So these appellate bodies are like supposed to be removed, and normal functions like existing judicial bodies, normal high courts, जो existing judicial bodies है वो normal high courts के पास, वो normal high courts हैं, उनके पास पहुंच जाएगी. बात समझ में आ गई आपके? Appellate body, Appellate Tribunal under the Cinematograph Act 1952. ठीक है, इसका रोल क्या है? इसका रोल है adjudication of appeals against the Board of Film Certification. ओके, ये appellate body है. अभी ये यहां से हटके हाई कोर्ट के पास चला जाएगा. ठीक है, Appellate Tribunal under the Cinematograph Act of 1952. रोल इसका क्या है? Adjudication of appeals against the Board of Film Certification. ओके, आप जैसे मैंने कल पढ़ाया था सिनेमाटोग्राफ एक्ट ऑफ 1952. ठीक, सिनेमाटोग्राफ एक्ट ऑफ 1952 में CBFC है, सेंट्रल बोर्ड ऑफ फिल्म सर्टिफिकेशन. फॉर एग्जाम्पल, यू आर अ फिल्म मेकर and your film is completely rejected by the CBFC. So where will you go? Where will you file an appeal? There is an appellate tribunal under the Cinematograph Act of 1952. And what is the role of that appellate tribunal? The role is the adjudication of appeals against the Board of Film Certification. It hears and entertains appeals against the decisions of the Central Board of Film Certification. And if still you are not satisfied with the judgment of the Appellate Tribunal of the Cinematograph Act, okay, if you are still not satisfied with the I hope there is no technical glitch. Are you able to hear me? Are you able to hear me? Come on, tell me. Okay. Then there is no, Ankita, NCLT is not an appellate tribunal. NCLT is National Company Law Tribunal. National Company Law Appellate Tribunal is the appellate body under the company law. Okay. Now, Appellate Board under the Trademarks Act. What kind of noise? There's no noise at my end. There's no noise at my end, at least. You might be receiving some disturbances from other ends, but like I am sitting in a very peaceful room. Okay. So Appellate Board under the Trademarks Act 1999, adjudication of appeals against orders of the registrar. There is one Appellate Board under the Trademarks Act of 1999 which hears and adjudicates of appeals against the orders of the registrar. Trademarks, Registrar of Trademarks. ठीक है? Yes, it has appellate body also. Come on, leave. For God's sake, leave NCLT now. I just cited an example, cited it as an example. Come on, leave it now. Appellate Board under the Copyright Act of 1957. Adjudication of certain disputes and appeals against orders of the Registrar of Copyright. Disputes include those related to publications and term of the copyright. Okay. See, like these on the left hand, on the left you can see that we have certain laws. Okay. And the appellate bodies it has created, the law has created, like the appellate body under the Cinematograph Act of 1952, appellate body under the Trademarks Act of 1999, then appellate body under the Copyright Act of 1957. Okay, we have like different laws which have created different appellate tribunals. Okay, similarly, like under the Customs Act of 1962, the role of this Custom Tribunal, Appellate Tribunal is the adjudication of appeals against orders of the Customs Authority for advance rulings. Appellate Board under the Patents Act 1970, adjudication of appeals against decisions of the controller on certain matters. Matters include applications for patents and restoration of patents. Okay. Airport Appellate Tribunal under the Airports Authority of India Act 1994, adjudication of disputes arising from the disposal of properties left on airport premises by unauthorized occupants and for appeals against order of an eviction officer. So like there was an appellate tribunal under the Airports Authority of India Act also of 1994. Okay, then Airport Appellate Tribunal under the Control of National Highways, Land and Traffic Act 2002. What it hears and adjudicates upon? It adjudicates adjudication of appeals against orders of the Highway Administration and matters including grant of lease or license of highway land, removal of unauthorized occupation, and prevention of damage to highway. Okay, then Appellate Tribunal under the Protection of Plant Varieties and Farmers' Rights Act 2001. You must have read this act in the IPR. Adjudication of appeals against certain orders of Registrar or Plant Varieties and Farmers' Rights Authority. Okay. Then Appellate Board under the Geographical Indications of Goods Registration and Protection Act 1999. Adjudication of appeals against orders of the Registrar. Okay. Now here the sources. The Tribunal Reforms, Rationalisation and Conditions of Service Bill 2021, like parent acts of the appellate bodies, we have categorized the parent acts of the appellate bodies. Okay, now the search cum selection committees. The Finance Act 2017 specified that the chairperson and members of the tribunals will be appointed by the central government on the recommendation of a search cum selection committee. The bill amends the bill amends the 2017 Act to specify that these committees will consist of 1. The Chief Justice of India or a Supreme Court judge nominated by him as the chairperson with a second casting vote in case of a tie. Okay. There's going to be a search cum selection committee. Now read this paragraph and listen to me very carefully because this paragraph contains the procedures for the appointments of the chairperson and members of the tribunals. Okay. The Finance Act 2017 specifies that the chairperson and members of the tribunals will be appointed by the central government on the recommendation of a search cum selection committee. There's going to be a search cum selection committee. This search cum selection committee is going to recommend the names of the persons to be appointed as chairpersons and members of the tribunals to the central government, and the central government is finally going to appoint them. So the bill amends the 2017 Act to specifies that these committees will consist of 1. The Chief Justice of India. This committee will sit the Chief Justice of India or a Supreme Court judge nominated by him as the chairperson with the second casting vote in case of a tie. 2. Two secretaries nominated by the central government. 2 secretaries nominated by the central government. 3. The sitting or outgoing chairperson or a retired Supreme Court judge or a retired Chief Justice of a High Court. And 4. The secretary to the ministry under which the tribunal is constituted with no voting right. Like there is going to be a secretary of the concerned ministry. Okay, concerned ministry. Like for example, Ministry of Environment, Forest and Climate Change. It covers National Green Tribunal. So the secretary, like if the search cum selection committee is being composed and is being constituted for the appointment of chairperson and members of the National Green Tribunal, then definitely this 4th person is going to be the secretary to the Ministry of Forest, Environment and Climate Change. Okay, so the secretary to the ministry under which the tribunal is constituted. We have Cinematograph Act. Like Cinematograph Act अभी हमने पढ़ा, यहाँ पे देखिए पहला है Appellate Tribunal under the Cinematograph Act of 1952. ठीक, अगर Cinematograph Act के ट्राइब्यूनल में चेयरपर्सन और मेंबर्स अपॉइंट होने हैं तो कौन कौन ये सब लोग बैठेंगे, ये सब लोग बैठेंगे. देखिए चीफ जस्टिस ऑफ इंडिया, अगर चीफ जस्टिस ऑफ इंडिया नहीं बैठ रहे तो सुप्रीम कोर्ट जज बैठेगा हु इज नॉमिनेटेड बाय हिम. देन चेयरपर्सन as the chairperson, then 2 secretaries nominated by the central government, कोई भी 2 senior IAS officers. तीसरा the sitting और outgoing chairperson जो रिटायर हो रहा है और रिटायर्ड सुप्रीम कोर्ट जज और रिटायर्ड चीफ जस्टिस ऑफ अ हाई कोर्ट. एंड 4th कौन बैठेगा, सेक्रेटरी टू द मिनिस्ट्री ऑफ इंफॉर्मेशन एंड ब्रॉडकास्टिंग, because that is under which the tribunal is constituted. Term of office under the Finance Act 2017, the 2020 rules specified a 4-year term of office for members. The bill amends the 2017 Act to include provisions related to term of office in the Act itself. The bill retains the term of office at 4 years subject to an upper age limit of 70 years for chairperson and 67 years for other members with provision for reappointment. Okay, now part B, key issues and analysis. Tribunals are quasi-judicial bodies that are parallel to the court system in India. In India, some tribunals are at the level of subordinate courts, like somebody said, baat jazbaat ho tum said that वो motor accident claims tribunal है ना, मोटर एक्सीडेंट क्लेम ट्राइब्यूनल्स जो हैं वो सबऑर्डिनेट कोर्ट्स के लेवल पर हैं, है ना. अपील कहाँ होगी, हाई कोर्ट में होगी. सो ट्राइब्यूनल्स आर क्वासी जुडिशियल बॉडीज दैट आर पैरेलल टू द कोर्ट सिस्टम. In India, some tribunals are at the level of subordinate courts with appeals lying with the High Court, while some others are at the level of High Courts with appeals lying with the Supreme Court. Okay. There are 2 main reasons for establishing tribunals: allowing for specialized subject knowledge for technical matters. Obviously, any person who is going to dispense cases of the company law must have some technical knowledge of company law. Before you are going to like sit or dispense case with regard to trademarks, you should know at least, something good content with regard to the Trademarks Act. Before you are going to sit as a judge in the in the cinematograph to deal with the case of Cinematograph Act, then you should have good knowledge of the act itself. So like there are some specialized subjects, there's some specialized fields which need some subject knowledge for technical matters. So there are two main reasons for establishing tribunals. One is allowing for specialized subject knowledge for technical matters and reducing the burden on the court system. Reducing the burden on the court system. For a discussion on the working of tribunals, we can have there's a link given, the tribunal system in India. Now, the bill and the ordinance, we read this. Appointments of presiding officers and other members of tribunals. Term of office for presiding officers and members violate principles laid down by the Supreme Court. Laid down by the Supreme Court. Up till here, do you have any doubt? Are you facing any problem up till here? Any question up till here? Any question? Okay, so I'm moving ahead. The bill and the ordinance specify that the term of office for the chairperson and members will be 4 years. On July 14, 2021, the Supreme Court struck down these provisions of the ordinance. The court stated that specifying 4 years of term of office violates the principles of separation of powers, independence of judiciary, rule of law, and equality before law. Over the years, the Supreme Court had stated that short tenure of members of a tribunal along with provisions of reappointment increases the influence and control of the executive over the judiciary. Okay. It also discourages meritorious candidates from applying for such positions as they may not leave their well-established careers to serve as a member for a short period. Like if you are appointed as a member of the tribunal for a very short period, then in that period you will have to leave your current job. You cannot do anything while being a member of the tribunal. You cannot do anything. Okay. You cannot do anything. So why would anybody leave his or her well-established career to serve as a member for a very short period? That is the question. So that's how this discourages the young talents. Also, this also discourages people from applying in to these posts. There's a question from Naman. Search committee will give recommendations or make appointments directly. See, search committee is going to make recommendations. Okay. It's going to make recommendations. And who is going to make the appointment? The central government is going to make the appointment. Have you read about the appointments of the judges of the higher judiciary? The way there is a, collegium system. Okay. The collegium system makes recommendations. And who appoints the judges of the Supreme Court? The President of India. So this appointment process is just a mere, rubber stamp. It's just a rubber stamp. Simply, search committee is actually making a de facto appointment by recommending the names. The central government is just putting a rubber stamp on the appointment letters. That's it. So the one who puts the rubber stamp, no matter the appointing authority might not have any say in the recommendation process, is said to be the appointing authority. Okay. So the search committee will give the recommendations and the central government is going to make the appointment. Okay. The court has also noted that security of tenure and conditions of service are core components of independence of the judiciary. The Supreme Court had stated that the term of office for the chairperson and other members must be 5 years, subject to a maximum age limit of 70 years for the chairperson and 67 years for other members. Okay, minimum age requirement of 50 years for appointment as a member. The bill and the ordinances specify that a person must be at least 50 years old to be appointed as a member of a tribunal. This violates past Supreme Court judgments and was also struck down by the court in July 2021. While reviewing the ordinance in 2021, the Supreme Court reiterated earlier judgments which emphasized the recruitment of members at a young age. In past judgments, the Supreme Court in 2020 has stated that advocates with at least 10 years of relevant experience must be eligible to be appointed as judicial members, as that is the qualification required for a High Court judge. A minimum age requirement of 50 years may prevent such persons from being appointed as tribunal members. I've already discussed this point. Abolishing tribunals may increase disposal time for new cases. This is going to be the new problem. Not the new problem. Actually, this was the problem that we have been facing for quite a very long time. But this is going to be repeated again if the tribunals are going to be abolished. The bill and the ordinance abolish certain existing appellate bodies and transfer their functions to high courts. This may further increase the disposal time for cases. The statement of objects and reasons of the 2021 bill states that data from the past 3 years shows that the presence of tribunals in certain sectors has not led to faster adjudication, and such tribunals add considerable cost to the exchequer. It also states that these amendments would address the issue of shortage of support staff and infrastructure in such tribunals. However, transferring functions of an appellate body to a high court may lead to a further increase in the disposal time of cases, as most high courts already have high pendency. Note that as of July 2021, there are over 59 lakh cases pending in the high courts across India. This defeats the purpose with which these tribunals were set up, which was to help reduce the burden on high courts. Further, if there is an issue of shortage of administrative capacity at such tribunals, it may be questioned whether the capacity should be increased or their case load be shifted to other courts. The Supreme Court considered the question whether amalgamation of tribunals could increase litigation, which in the absence of adequate infrastructure or budgetary grants would overburden the judiciary. Like, it's written in a very simple language. This is like I'm giving the lecture. It noted the absence of such judicial impact assessment and directed the central government to undertake an exercise to assess requirements and make sufficient resources for each tribunal. Neither the Finance Act 2017, which reorganized several tribunals, nor this bill provide a financial memorandum that estimates the resources required as a result of their provisions. So this is going to increase the disposal time. This is going to be more time consuming. This is going to burden the high courts again with lots and lots of cases. Amalgamation of 2 tribunals or 3 tribunals or 2 or 3 or more tribunals together would increase the amount of litigation, because so many cases are going to be disposed of by the same institution, which is going to be a new amalgamated institution. So these kinds of things are going to create some problems in the future, and this is a worrisome situation right now that we are stepping into. Okay, now this is all about today's topic. Do you have any question? What kind of questions can be asked from this, Angita? So many questions can be asked from this, because this PDF doc and this topic is full of information. Okay, is full of information. Like, we have lot of things like Tribunal Reforms Ordinances 2021 deals with amalgamation of tribunals based on functional similarities. Okay, then it contains like you can read the key features. You can read the key features of this the Tribunal Reforms Ordinances Ordinance 2021. Okay, the Supreme Court struck down. The Supreme Court suggested 5 years. Okay, however, the term of office was decided earlier to be the 4 years. The Supreme Court, okay, the Supreme Court wanted it to be 5 years. Okay, excess of, like, we have this table. Go through this table. That this table is very important. We have an appellate tribunal under the Cinematograph Act of 1952, and it goes on, and read their roles. These are the appellate bodies which have been specifically targeted by the Tribunals Reforms Bill 2021. Okay, you can read them. Just go through this PDF. You can find lots and lots of questions. Okay. What is going to be the composition of the committees? Who is going to sit as the in the search cum selection committees? Then who shall be the appointing authority? The Union government. Okay. Then the Chief Justice of India or a Supreme Court judge. Read this paragraph. This is full of information. Any more questions? Right now, Astha is asking, there is a confusion between the criticism made by the Supreme Court and was that final, or are these rules final? Right now, the situation is that these rules are final. Unless they are challenged again before the Supreme Court, these rules and this ordinance is final. Okay. Any more questions? I'm waiting for questions. You're most welcome to ask. Okay, so I am ending the stream now, hoping that the topic is clear to you. Okay, all the very best. See you tomorrow. Bye bye.